Hello everyone, good morning. Welcome to this lecture series on the law on obligation and contracts. In this portion, we're going to discuss about application of payments. So let me share my screen with you. Okay, application of payments. Let us define first what is application of payments mean. Now, application of payments means the designation of the debt to which should be applied the payment made by a debtor who has various debts of the same kind in favor of one and the same creditor. So when you say application of payments, in one word, application means the designation of the debt or designation, no? Simply designation. When you apply your payment, you designate which of the debts is the payment being applied to, no? Now you will see in the definition under Article 1252 that application of payments applies when there are various debts of the same kind in favor of one and the same creditor. So let us go to the requisites of application of payments. Number one, there must only be one debtor and one creditor. So 1:1. No? Number two, there are two or more debts. The law requires that there are two or more debts because otherwise, if there is only one debt, then you do not need to apply your payment because you will only be applying that payment to that particular obligation. So application of payments again presupposes that there are two or more debts of the same kind existing between the creditor and the debtor. 3, debts must be of the same kind. And that 4, debts to be paid must be due. And lastly, payment made rather must not be sufficient to cover all debts. Again, class, you have to remember that the payment must be insufficient. In other words, the payment made will not cover all the debts existing between the debtor and the creditor. Because again, obviously, if the payment will suffice to extinguish all debts, then you do not need application of payments. So remember these requisites under 1252. Now, as a general rule, you can only apply your payment if the debt is due. No? That is an for obvious reason. You cannot apply your payment as to debts which are not yet due. No? So, are there exceptions to the general rule? Yes. If the parties agree that the debtor can apply payment even to those debts which are not yet due, then the debtor may do so. Second, it is made by the debtor or creditor, as the case it may be, for whose benefit the period has been constituted. For example, if the period has been constituted in favor of the debtor, then he can opt to waive, or he can opt not to make use of that period and pay the debt even if it is not yet due. But that will apply only if the period has been constituted in favor of the debtor. On the other hand, if the period has been constituted in favor of the creditor, then obviously the debtor may not opt to apply the payment to debts which are not yet due. Okay? Now, let us go to rules on application of payments. So these rules will govern on how the debtor or creditor will have to apply the payment made. Now, the debtor must indicate that at the time of making payment, which particular debt is being paid. So you have to identify which of the debt is being paid, and the period of time of the designation or the application is at the time of making payment. In other words, the debtor would not be allowed to apply payment after the fact of making payment. Application can only be done at the time of making of the payment. Note that if the debtor applied the payment to a debt, he cannot later on claim that it should be applied to another debt. Second, when choice has been exercised by the debtor, meaning when the debtor has opted to apply this payment to a particular debt, that choice becomes irrevocable. In other words, class, the debtor cannot change his mind and after making the application, revoke it and transpose it to another debt. That cannot be done. The choice, once exercised, is irrevocable. Except, of course, if the creditor consents to the change. Um, for instance, if the creditor would accept the revocation of the application of payment. Now, number three, the creditor may make the designation by specifying in the receipt which debt is being paid. Now, as a general rule, class, who between the debtor and the creditor has the right to make application of payments? Is it the debtor? Is it the creditor, or either of them? The answer is it is the option of the debtor. Now, if the debtor fails or refuses to exercise his right to apply his payment, then the creditor may apply or may make the designation by specifying in the receipt which debt is being paid. In other words, upon the failure of the debtor to apply the payments made, then the creditor may do so. And how can the creditor apply the payment made? He can indicate in the receipt the particular debt to which the payment is being applied. Okay? 4. The most onerous debt or the most burdensome. When you say most onerous, this debt has the most encumbrance. This is more burdensome on the part of the debtor. Now, that most onerous debt to the debtor among those due shall be deemed to have been satisfied. If there are several debts which are due, then that is which is the most onerous is the payment is to be applied. Okay. This applies also if the creditor has not made the application. Okay. You only apply this fourth rule if the creditor also has not made the application. So in case that there are several debts due, you apply to the most onerous debt. For example, when you say onerous, if a contract of loan has been secured by a real estate mortgage, then that is the most onerous debt. When you say most onerous, it is more burdensome. There are more obligations to it. Because in case that the debtor fails to pay, then the property he constituted as mortgage can be foreclosed. Correct? So that makes it more onerous. So in case that the debtor and the creditor fails to exercise the right to make the application, then you apply the debt to the most and onerous debt, assuming that there are several debts that are due. Okay? Now, the payment shall be applied to the debts proportionately. Okay? if the debts are of the same nature and burden. Assuming that there is no most onerous, all of the loan is without or are without security or without mortgage. How do you apply the payment made? Then it should be applied proportionately to all debts. Okay? Okay. Let us go to Article 1253. As a general rule, class, the payment must be applied first to the interest before the principal, except if there is an agreement existing between the parties or there is waiver by the creditor. In other words, class, the debtor may not insist that this payment will be applied to the principal obligation first. Under Article 1253, the payment is to be applied first to the interest before the principal. And can there be an instance where payment is to be applied first to the principal and not to the interest? Yes. If there is an agreement or if there is consent or waiver on the part of the creditor. Okay. The creditor can refuse application of the debt made contrary to the provision of Article 1253. In other words, class, the debtor has no right to insist on the payment or the application of payment to the interest first. Okay. Let us go to Article 1254. Now, the Supreme Court ruled in determining which debt is more onerous than the other. Now, if the loan has interest imposable, then it is more onerous than those loan which has no interest, for example. So interest-bearing debt is more onerous than non-interest-bearing debt. Second, a debt as a sole debtor is more onerous than a solidary debtor. Okay? Third, debts secured by a mortgage or pledge is more onerous than unsecured debts. Fourth, debt with higher rate of interest is more onerous than the other. Fifth, obligation with the penal clause. We have discussed this when we were discussing about the different kinds of obligation. Obligation with a penal clause than without a penal clause. So that is subsection 1 on rules on application of payment. We go to subsection 2. Subsection 2 is about payment by cession. This is an important provision of the law. So pay attention to this discussion. Let us go to Article 1255, payment by cession. What is payment by cession? When you say payment by cession, that means that there is an assignment or abandonment of all the properties of the debtor for the benefit of his creditors in order that the latter may sell the same and apply the proceeds thereof to the satisfaction of their credits. So if you describe payment by cession in one word, that word is assignment. Payment by cession is assignment or abandonment of what? Of all properties of the debtor. For the benefit of whom? The creditors, in order that the creditors may sell these properties and apply the proceeds thereof to the satisfaction of their credits. Let us go to the requisites of payment by cession. Memorize these requisites. One, there must be two or more creditors. Number two, the debtor must be partially insolvent. Number three, the assignment must involve all properties of the debtor. And number four, the cession must be accepted by the creditors. So let us take these requisites one by one. Unlike in application of payments, in payment by cession, there are two or more creditors. Class, remember that. Payment by cession will not apply if there is only one creditor. Take note. Now, if you think of payment by cession, always remember that payment by cession presupposes that the debtor is partially insolvent. He is partially insolvent. Now, what property or properties must be assigned by the debtor? The assignment must involve all the properties of the debtor, meaning all properties, not one property, not some properties, but all properties of the debtor. Okay? Now, and fourth, the cession must be accepted by the creditors. Now, under Article 1255, as a general rule, the assignment or payment by cession does not make the creditors the owners of the property of the debtor, and the debtor is released from his obligation only up to the net proceeds of the sale of the property assigned. Okay, I will repeat. The assignment does not make the creditors the owners of the property of the debtor, and the debtor is released from his obligation only up to the net proceeds of the sale of the property assigned. Now, question. In payment by cession, in case that the partially solvent debtor will assign all his properties to the creditor, is there a transfer of ownership from the debtor to the creditor, meaning the creditors can now exercise rights of ownership over the property? Answer, no. In payment by cession, there is no transfer of ownership from the debtor to the creditor. Now, question. If there is no transfer of ownership from the debtor to the creditor, then what is acquired by the creditors in payment by cession? Now, answer. The right acquired by the creditors is not ownership over the property, but the right to subject the properties to a public auction. Those properties of the debtor will remain to be owned by the debtor, except that it will be sold in a public auction, and that the proceeds of that sale will be applied to the obligation. Now, the more important question is, will the application of the net proceeds of the sale will affect the extinguishment of the obligation? Answer, it will extinguish the obligation up to the extent of the net proceeds of the sale. In other words, the debtor is released from his obligation insofar or up to the extent or in as much as the net proceeds of the sale is applied to his obligation. In other words, class, in payment by cession, there is only partial extinguishment of the obligation. When you say partial, the extinguishment will only be coterminus, quote unquote, no? Or will only be up to the amount of the net proceeds of the sale. It will all depend upon the net proceeds. If the net proceeds will suffice to pay the entire amount, then the obligation is completely extinguished. However, if the net proceeds will not suffice, then the uh, the obligation is only partially extinguished. Okay. Except when there is a stipulation to the contrary. Okay. Take note, class, that dation in payment, or what you call dashon and pago, and payment by cession are both substitute forms of payment or performance. Kasi class, in both dashon in payment or dashon and pago and payment by cession, instead of payment of a sum of money, what is being paid is or are properties of the debt. Okay, which is why they are considered as substitute forms of payment or performance. Now, flashed in your screens are the distinctions between dashon and pago and payment by cession. Okay. Now, in dashon and pago, there is only one creditor. One debtor, one creditor, just like in application of payments. On the other hand, in payment by cession, there are two or more creditors. Tandaan niyo, class, ha? If there is only one creditor, then there can be no payment by cession. Now, is there insolvency of the debtor in case of dashon and pago? Is the debtor insolvent in dashon and pago? Answer, no. How about in payment by cession? Yes. Payment by cession presupposes that the debtor is insolvent at the time of the assignment. Now, let us go to the extent of property to be assigned by the debtor. In dashon and pago, not all properties of the debtor will be assigned to the creditors. Again, not all. It can be one. It can be some, but not all. It will not involve all the properties of the debtor. On the other hand, in payment by cession, since the debtor is insolvent at the time of the assignment will extend to all the properties of the debtor subject to execution. Okay, take note of that. Now, is there transfer of ownership from the debtor to the creditor in dashon and pago? Yes. In dashon and pago, the creditor becomes the owner of the thing. On the other hand, in payment by cession, is there transfer of ownership? As we have discussed, there is none. The creditors only acquire the right to sell the thing and apply the proceeds to the credits proportionately. Okay? Now, is there novation in dashon and pago? Yes. Dashon and pago is an act of novation. Because instead of payment in money, the creditor will accept payment in the form of a property. There is a change in the mode, in the means of payment. Okay? Okay. Now, is there novation in payment by cession? No, none. There is no novation in payment by cession. Why? Because in payment by cession, the creditors will be paid in cash. No? Coming from the net proceeds of the sale. So that ends subsection 2. Payment by cession. Let us now go to subsection 3, tender of payment and consignation. Okay. Article 1256, tender of payment. Tender of payment is an act on the part of the debtor of offering to the creditor the thing or amount due. So when you say tender, it means offer. Now, offering to the creditor the thing or amount due. The debtor must show that he has in his possession the thing or money to be delivered at the time of the offer. What about consignation? Consignation is the act of depositing the thing or amount due with the proper court when the creditor does not desire or cannot receive it after complying with the formalities required by law. It is applicable when there is a debt and an obligation to pay. And it is always judicial. No, there is no such thing as extrajudicial consignation. Consignation is always done with the courts of law. And that consignation requires a prior tender of payment, which is extrajudicial. Now, memorize the requisites of a valid consignation. Now, let us go to them one by one. First, existence of a valid debt which is due. Second, tender of payment by the debtor which was refused without justifiable reason by the creditor. So there is what? Delay on the part of the creditor to accept the payment without justifiable cause. Third, there is a previous notice of consignation to persons interested in the fulfillment of the obligation. So there must be a first notice. You have to notify that you are consigning the property, no, to the persons interested in the fulfillment of the obligation. Fourth, there must be consignation of the thing or sum due. Okay. And then fifth, there must be second notice. No? The second notice is the subsequent notice of consignation made to the interested parties. So again, you have to notify first that you are consigning the property because there was an unjustifiable refusal on the part of the creditor to accept the payment. Now, after notifying them that you are consigning the property or the payment rather, or the sum due to the court, then you have to consign the thing or the sum due. And after consignment, there is a second notice. Subsequent notice of consignation made to the interested parties. Take note that the debtor will be relieved from payment of any interest from the date of the tender of payment. Take note of that, from the date of tender of payment. Now, there are instances wherein tender of payment is no longer required. You will take note that in the requisites of a valid designation, under number 2, there must be tender of payment and unjustifiable refusal to accept on the part of the creditor. So there are certain instances where tender of payment is no longer required, and therefore you can proceed to consignation even without tender of payment and unjustifiable refusal to accept. When the creditor is absent or unknown or does not appear at the place of payment. For example, if the agreement will provide that the payment is to be made at 1234 1 Luna Street, and then the creditor does not make himself available or present at the time and place of payment. then tender of payment is no longer required. Number two, when the creditor is incapacitated to receive the payment at the time it is due. For example, uh, the creditor is incapacitated. For example, he is under guardianship, no? Or there is another person who is appointed to receive payment on behalf of the creditor. Okay. Now, when without just cause the creditor refuses to give a receipt of payment, then number four, when two or more persons claim the same right to collect. In other words, there are several persons claiming the right to collect the payment. Then you need not tender payment, because otherwise the debtor will run the risk of payment to a wrong person or to the wrong creditor, right? Because there are two or more persons which are disputing the right to collect. Five, when the title of the obligation has been lost. Now, what are the requirements for a valid tender of payment? One, tender of payment must comply with the rules on payment or with the terms required by the contract in making such tender. Number two, it must be unconditional and for the whole amount due and in legal tender. Now we have discussed what is the concept of legal tender. Number three, it must be actually made. Now let us go to Article 1257. In the absence of prior notice to the persons interested in the fulfillment of the obligation, the consignation as payment shall be void. So class, take note na, if there has been no prior notice, then the consignation shall be void. Obviously, because the requisites have not been complied with. Diba? The first notice. Now, what is the purpose of notifying those persons interested in the fulfillment of the obligation before consignation is made? This notice is to give the creditor a chance to reflect on his previous refusal to accept payment and accept payment before consignation is to be made. After the consignation has been made, interested parties must be notified thereof. This is the second notice. Now, what is the purpose of the second notice? The second notice is to enable the creditor to withdraw the thing or sum deposited in case he accepts the consignation. Since consignment is made to the court, there has been no payment to the creditor directly. The second notice will allow the creditor to go to the court where the payment was consigned and he can withdraw it from that particular court. Okay, now Article 1259. Consignation expenses. Charged to the creditor, chargeable to the debtor. No? Because of the fault or unjust refusal of the creditor to accept payment, then consignation expenses are to be charged to the creditor. It can also be chargeable to the debtor if the consignation is not properly made. Now, when is consignation deemed properly made? Number one, creditor accepts the thing or sum deposited without objection, questions the validity of the consignation, or neither accepts nor questions the validity of the consignation. And that the court, after hearing, declares that it has been properly made. After hearing, orders the cancellation of the obligation. Kasi class, if the debtor would like to settle his obligation but the creditor unjustifiably refuses to accept the payment, then what is the remedy of the debtor? No? So the debtor will have to consign the payment to the court so that it is also a way of extinguishing the obligation, right? Now, take note that the running of the interest will cease or will stop or will be halted upon tender, not upon the completion of consignation. Take note of that. Now, once that consignation is properly done, then the court will order the cancellation or extinguishment of the obligation. Now, under Article 1260, when the consignation has been made, the debtor can order the cancellation of the obligation, may withdraw the thing or sum deposited before the creditor has accepted the consignation or before a judicial declaration that the consignation has been properly made. Now, class, unless and until that these two bullets are complied with or either of them will happen, then the debtor can lawfully withdraw the thing deposited. For example, the creditor is yet to accept the consignation, then the debtor can withdraw the thing deposited. Or before a judicial declaration that consignation has been properly made, then the debtor can withdraw the thing deposited or the sum deposited. Debtor's withdrawal with creditor's consent and without creditor's consent. The creditor shall lose every preference which he may have over the thing if the debtor's withdrawal is with the creditor's consent. On the other hand, if the debtor's withdrawal is without creditor's consent, then all expenses are paid by the debtor, and the obligation shall continue to remain in force. With creditor's consent, what is the effect on the guarantors and sureties? They are released. How about the solidary debtors? They are released only from their solidary liability but not from their shares of the obligation. Take note of this one. Okay. Section 2, loss of the thing due. This is pretty much straightforward. A thing is considered lost when it perishes, when it goes out of commerce, when it disappears in such a way that its existence is unknown. As a general rule, the loss of the terminate thing extinguishes the obligation. Exceptions, when the law provides, when the obligation requires assumption of risk, when there is a stipulation to the contrary, when the debtor contributed to the loss, when the debtor had already incurred in delay, when the debtor promised to deliver the same thing to two or more persons, and if the obligation proceeds from a criminal offense, and if the obligation is generic, because of the principle that genus never perishes. 1263. Loss of generic thing does not extinguish the obligation. Partial loss is a loss of a portion of the thing, or when it suffers depreciation or deterioration. It is equivalent of difficulty of performance in an obligations to do. Take note, class, that the court can decide whether there is partial loss or whether the partial loss is such as to be equivalent to a complete or total loss. So what is the effect of partial loss? If it is significant, then it is enough to extinguish the obligation. If partial loss is not significant, then it would not be enough to extinguish the obligation. If there is fault or negligence of the debtor, then the creditor has a right to demand rescission plus damages. If loss is due to a fortuitous event, then it depends. No? Substantial loss, the obligation is extinguished. Insubstantial loss, debtor shall deliver the thing promised in its impaired condition. Okay. So take note, class, of legal and physical impossibility. Okay? Now, class. Now, what is the effect of a fortuitous event where the obligation proceeds from a criminal offense? For example, there is a commission of the crime of theft. Now, there is theft when there is unlawful taking of a property belonging to another. Now, for example, the thing that was subject of theft was also lost because it was destroyed by fire, or when the place was inundated, then the object was beyond repair. No, it's now beyond repair rather. Now, what is the effect in case that the thing subject of a crime or a criminal offense was lost due to a fortuitous event? Then the obligation will still exist, except when the creditor refused to accept the thing offered to him. Okay. Section 3, condonation or remission of debt. What is condonation? It is the gratuitous abandonment by the creditor of his right against the debtor. Requisites of condonation: it must be gratuitous, it must be accepted by the obligor, the parties must have capacity, it must not be inofficious, and if made expressly, it must comply with the forms of donations. Class, kasi when debts are condoned, no, when debts are abandoned or remitted, then it is also equivalent to a donation. Hindi ka na pinagbabayad. So it is as if that the creditor is taking the person of the donor and the debtor as the donee. Kaya nga under the requirement number 5, if there is condonation, then you have to comply with the formalities required in a donation. Meaning, the debtor must accept the condonation. There are kinds of remission: complete, partial, express, implied, inter vivos, mortis causa. When you say inter vivos, this takes effect during the lifetime of the creditor donor. In mortis causa, it will take effect upon the death of the creditor donor. Okay. Okay. I think this is some of these are very much straightforward. I'll just leave them to you. Okay. Section 4, confusion or merger of rights. Okay. What is confusion or merger? It is the meeting in one person of the qualities of the creditor and debtor with respect to the same obligation. What are the requisites of merger or confusion? It must take place between the principal, debtor, and the creditor. It must be complete. Now, take note, class, that merger takes place in principal, debtor, or creditor. No? If the obligation and the contract of guarantee, for example, what has been merged in one person is the creditor and the contract of guarantee, then it will extinguish the obligation. This is an exception actually under the law. Kasi as a general rule, there can only be merger or confusion if confusion happened between the principal, debtor, and the creditor. Now, question, yung contract of guarantee kasi, this is not principal contract. This is accessory contract. Now, for example, the person of the creditor merges with the guarantor. Will it extinguish the obligation? Yes, as an exception. Huh? As a general rule again, merger can only take place between the principal debtor and the principal creditor, except when the merger takes place between the creditor and the guarantor. Okay. Now, guarantor. does not extinguish the obligation, only the contract of guarantee. The guarantor becomes the new creditor and can demand payment from the debtor. What about if the merger takes place in a joint obligation? Merger will extinguish only the share corresponding to the creditor or debtor in whom the two characters occur. In a solidary obligation, it will extinguish the entire obligation. Okay. Compensation or set-off. Compensation or set-off is the extinguishment of the concurrent amount of debts between two persons who in their own right are debtors and creditors of each other. There are kinds of compensation: total or partial, legal, voluntary, judicial, facultative. When you say legal, it takes place by operation of law. Legal compensation. No? It takes place by operation of law, even parties are without knowledge. Voluntary. It takes place by agreement of the parties. Okay? Judicial. It takes place by order from a court in litigation, and facultative, it can be set up only by one of the parties. Take note of these distinctions between compensation and confusion. In compensation, there are two persons involved, each of whom is a debtor and creditor of each other. May utang ka sa kanya, may utang rin siya sa'yo. Di ba? Compensation. Now, confusion. There is only one person, and that person is the creditor and debtor of himself. Iisang tao lang. Nag-merge yung qualities ng creditor at debtor, kaya na-extinguish ang obligation. Because no person in his right mind will collect and pay for himself. Diba? Now again, in compensation, there are two persons involved, but in confusion, there's only one person involved. There are two obligations in compensation. Dalawa. One in the creditor and one in the debtor. But in confusion, there is only one obligation. Third, there is indirect payment. And in confusion, there is impossibility, or I will say impracticality of payment. Memorize the requisites of Article 1279 on legal compensation. Memorize, memorize, memorize. Always been the topic of exams. What are the requisites of legal compensation? The parties are principal creditors and principal debtors of each other. Number 2, both debts consist in a sum of money or consumable things of the same kind and quality. 3, two debts are due and demandable. 4, two debts are liquidated. And number 5, there is no retention or controversy commenced by a third person. This is what I'm talking about, no? This is an exception to Article 1279. If you go to 1280, the law allows that the guarantor may set up compensation as regards what the creditor may owe the principal debtor. Pwede. Reason, third person is giving the right to set up compensation because extinguishment of the principal obligation as a consequence of compensation carries with it the extinguishment of the accessory obligation. Total compensation or partial compensation, very easy to understand. Voluntary or conventional compensation takes place by agreement of the parties, even if the requisites of 1279 are not complied with. Kasi obviously, class, pagka kompleto ang requisites in 1279, then you do not need to agree. By operation of law, the obligation is extinguished. But if the requisites of legal compensation are not all present, then the parties can still agree, but it is no longer legal compensation, but this time only voluntary or conventional compensation. Judicial compensation. It is the setting off of a claim between the parties in a litigation. Now, rescissible and voidable contracts, class, these are valid contracts unless they are judicially rescinded or avoided. Prior to rescission, debts may be compensated. Okay? Compensation before assignment and with consent, the debtor loses the right to set up the defense of compensation. Compensation after assignment with consent, the debtor loses the right to set up defense of compensation. If there is a reservation to the right of compensation, it will take effect. Compensation after assignment with knowledge and but without consent, the debtor can only set up compensation before the cession. And after assignment without knowledge, the debtor can raise the defense of compensation. Memorize this graph. Okay, memorize. Please memorize. Okay, foreign exchange rate. There are certain contracts or special contracts or transactions which legal compensation is prohibited. Meaning to say, even if the requirements under Article 1279 are present, you cannot still apply legal compensation. In a contract of depositum, in a contract of depositum, deposit is constituted from the moment a person receives a thing belonging to another. No, in a contract of depositum, legal compensation is not allowed. For example, you are traveling abroad and you would like to uh, to transfer to another person a valuable property for safekeeping. That is a contract of depositum. Now, that person to whom the property has been deposited happens to be your creditor. Pwede bang sabihin ng creditor mo na, oh sige, wag mo na akong bayaran. O kaya, total, ayaw mo naman akong bayaran, hindi ko na ibabalik sa iyo ito, itong dineposit mo. Ha? Akin na lang ito. Apply ko na lang to sa property, sa utang mo. Now, question, can there be legal compensation? The law says no. There can be no legal compensation in case of contract of depositum. Iba naman yung deposit or bank deposit. Ang bank deposit, pwede dyan magkaroon ng legal compensation as decided by the Supreme Court. Why? Kasi in a bank deposit, the depositor is considered as the creditor of the bank. There is debtor-creditor relationship between a depositor and the bank. Kaya nga pag nag-deposit ka sa banko, you are said to be a creditor of the bank. Ikaw ang pinagkakautangan ng bangko. And the payment of interest there is an evidence of a loan. Pinapautang mo ang bangko whenever you open a deposit account with the bank. No? So in a contract of bank deposit, there can be legal compensation again because there is debtor-creditor relationship between the bank and a depositor. But ordinarily, in a contract of depositum, meaning safekeeping of a personal property, no, then there can be no legal compensation. In a contract of comodatum, class. What is a contract of comodatum? Comodatum is a gratuitous contract whereby one delivers to another something not consumable so that the latter may use and return it. Ano ba sa Tagalog yung comodatum? Humiram ka. Humiram ka ng kotse, ba? Humiram ka ng ilaw, humiram ka ng sandok, humiram ka ng kaldero. Ang tawag dyan, comodatum. It is gratuitous kasi hindi mo inupahan. Kung may bayad yan, hindi na yung comodatum, lease, di ba? Upa. Now, comodatum, you cannot set up legal compensation. Ha? Halimbawa, hiniram mo yung gamit niya. Tapos may utang siya sa'yo. Pwede mo sabihin na, total naman, ayaw mo magbayad. Etong hiniram mo ko sa'yo, eto na ang pambayad mo. The law does not allow the application of legal compensation in a contract of comodatum. Why? Libre mo na ngang hiniram yun eh. It is a gratuitous contract. Pinahiram ka na nga lang libre tapos bigla mong kukunin, di ba? Okay? So, the law does not allow legal compensation in a contract of comodatum. And also, it is not allowed for claim of support due by gratuitous title. For example, child support. Bawal, no? Okay. Rules of application of payments apply to the order of compensation. Okay, 1290. Consent of the parties are not required in legal compensation. It takes place by operation of law. Let us go to section 6, novation. Malapit na tayong matapos sa extinguishment. Now, novation. Ano ba yung sabihin ng novation? Novation is the extinguishment or modification of an old obligation into a new one. Class. Sa extinguishment of obligation, dalawa ang pinaka-importante dyan. Legal compensation at novation. Dalawa. Okay? So, remember this concept, no, of novation and legal it has always been the subject of exams or questions in the exams. Okay? Okay. Now, when you say novation, it means extinguishment or modification of an old obligation into a new one. Kaya nga novation. Nova. It means there is something new. There's an old obligation and there is a new obligation. The new obligation will take the place of the old obligation. Nova. May binabago. Novation. Yan. Obligations can be modified by changing the object or principal condition. You can substitute the person of the debtor. You can subrogate a third person in the rights of the creditor. So these are the modes by which novation can be had. For example, di ba kanina sabi natin sa dasyon and pago, may novation. Why? Instead of paying in a sum of money, you pay property. So there is a change in the object or there is a change in the principal condition. So dasyon and pago is an act of novation. In payment by cession, can there be a novation? No. There cannot be novation in a payment by cession. Why? Because in payment by cession, the creditors are paid from the proceeds of the net proceeds rather of the public auction. They are not paid by the properties of the debtor. So walang novation. Na walang change in the object. Okay. Can be legal or conventional. Legal novation takes place by operation of law. Conventional novation takes place by agreement of the parties, expressed, implied, total, partial, or modificatory. It can be real or objective, personal or subjective, or mixed. Memorize the requisites of novation. Memorize. There must be a previous valid obligation. Kasi class, if the old obligation is void, then there can be no novation. Novation presupposes that the previous or old obligation is valid. Number 2, agreement to modify or extinguish the obligation. 3, extinguishment of the old obligation. And number 4, validity of the new obligation. Tandaan ninyo ang graph na yan. Expromission and delegation. Ano ba yung expromission at delegation? Depende kung sino ang nag-i-initiate ng substitution ng debtor. Pag ang nag-initiate ng substitution to the person of the debtor is the third person, meaning without the debtor's consent, it is called as expromission. When it is the debtor himself who initiates the substitution, then it is called as delegation. Again, pag third person, expromission. Pag si debtor ang nag-initiate ng substitution, delegation. Dine-delegate niya, di ba? Delegation. Now, what is the right of the payer? It depends. In expromission, there is only beneficial reimbursement. Pag third person ang nag-initiate na siya ang magbayad, pwede ba siya makakolekta? Depende kung ang bayad niya ay naging beneficial o kapaki-pakinabang sa debtor or sa may utang. Pag ang bayad ng third person ay naging kapaki-pakinabang sa may utang, then he can reimburse from the debtor. On the other hand, if the debtor himself initiates the substitution, sasabihin niya, ikaw na magbayad ng utang ko, ha? Can the payer reimburse from the debtor himself? Yes, absolutely. Whether or not the payment has been beneficial, the payer, can seek absolute reimbursement plus the right of subrogation. Ano ba yung right of subrogation? The payer will step into the shoes of the creditor and he can also exercise his rights. For example, he can foreclose the mortgage in case that the debtor will refuse to reimburse him. So again, if the third person will initiate the substitution, then there can only be beneficial reimbursement. Fair enough. Kasi pwedeng ayaw ni debtor na siyang magbayad. Diba? Without the debtor's consent. Pero pag si debtor ang nag-initiate ng substitution, then there is absolute right of reimbursement plus subrogation. Take note. Take note. Now, in expromission, the new debtor's insolvency or non-fulfillment shall not give rise to any liability to the original debtor. Okay? In delegation, the new debtor's insolvency shall not make the creditor revive his action to the original debtor unless insolvency already existed and is public knowledge and known to the original debtor at the time he delegated his debt. Ito ang pinaka-important na portion. Kapag ang third person ang nag-initiate ng payment without the debtor's consent, there can only be beneficial reimbursement. There is no right of subrogation. Now, what if the third person becomes insolvent? What if the third person becomes insolvent? Or what if the third person will not fulfill his promise to pay? Oh. Will it give rise to any liability to the original debtor? No? According to the Civil Code, the new debtor's insolvency or non-fulfillment shall not give rise to any liability to the original debtor. Tandaan niya ang class, In expromission. In delegation, wherein the debtor initiates the substitution, there is absolute reimbursement and right of subrogation. Now, if the new debtor becomes insolvent, it will not make the creditor revive his action against the original debtor unless insolvency existed and in public knowledge and known to the original debtor at that time he delegated his debt. Take note of this distinction. Very important. Okay. There is no novation if the new obligation is void and the original one shall subsist. Okay. Okay. Subrogation. Okay, I've explained this concept to you. There are two kinds, conventional, legal. Okay. Same, same. Okay. Legal subrogation, transfer of right. I will leave this to you. Okay. This ends our discussion on extinguishment of obligation. So next meeting, we're going to discuss about contracts. Thank you for listening and have a nice day.